texts.
Yes,
So,
emails and texts. We learned something recently. Well, it's a lesson we had to relearn over again. We just got done with a 1 week trial, and we learned that evidence comes in different classes. Some evidence is more important than others. And you and I were talking about this as we were going over the case. And just so everyone, so we're all, let's back up here for a second. Basically, when you go to trial, there's facts, witnesses, and documents, right? There's
those are the
facts.
three type of evidence that you have.
Yeah, so you've got undisputed facts. Those are facts that everyone agrees to. And then you've got disputed facts. That's where lawyers make their money, because you've got to prove up the facts the way that you see them. And then you have unknown facts, or facts that you need to develop. Generally, you do that through the discovery process before you get to trial. But we found out in trial, once again, in this new age, that there's something that's jumping out at us in how we prosecute the cases. Well, you want to talk about some of that?
Well, yeah, I mean, you can have people get up and testify, and they'll give their testimony as to what they saw and they were there. And the best witnesses when it comes to testimony are disinterested witnesses, right? People who are not going to have any type of result in the case. But when you have parties testifying, their credibility is always in question by the trier of fact, the judge or the jury, because they have a stake in the outcome. And so you're always wondering, are they saying this because it's true, or are they saying this because they want to win? But there's one thing that is kind of set in stone, and it can help you or it can hurt you big time. And that's what you put in writing, and that's text and emails. And that's what when you're talking about documentary evidence, it can be really, really strong. And sometimes a text or an email is going to help you, and other times a text or an email will totally destroy you in your case because it contradicts what you're trying to now testify to, or the story you're now trying to say. And
Yeah,
so,
and I think that a lot of times we see that when a lawyer disagrees with a text or an email, that probably the worst thing to do is try to explain it away, because we have a saying here at this firm that if you're explaining, you're losing. And
yeah.
so generally a text or an email, you're going to give it the plain meaning. You're going to look at it. You're going to read it in context with the other texts that are before it and after it, or email chains and so forth. But the other thing that we need to think about here too, Keith, is we're not just limiting to texts and emails, anything in writing. So, some of the older clients are going to have letters, right? So letters are in writing. Some of the newer generation is going to be social media, WhatsApp. I mean, all these apps I don't know about. There's going to be writings there. If there's writings there, they are gold. You got to go get those in the discovery process, because at the time of trial, it is so difficult to overcome a bad text or a bad letter or some other bad writing out there. And on the other hand, if you have a good writing, boy, it's worth its weight.
Well, think about a lot of our cases. We're trying, when you're doing a trust contest case, so you're going to come in and you want to say that, whatever last trust or trust amendment, it's not what mom or dad really wanted. Part of what you're going to have to show is that you had a good relationship with mom or dad. And that it's funny because that's not the legal standard, but from an equitable standpoint, you're going to have to show that if you're going to persuade somebody
Right.
that you're right. And what better way? When we were young, when we were kids, people would send each other birthday cards in the mail, or Christmas cards, or even letters or notes or whatever. And what happens when you have a good relationship with a parent, and a parent has a good relationship with a kid? They do things for each other. And so you'll have birthday cards, Christmas cards, notes, gifts, times when you get together. You don't have to get together every week or even every month, but you were in each other's lives. And now that's become harder to prove in some ways, because people don't necessarily send paper cards and things like that anymore. So what do? They leave comments on Facebook, or they send a text, or, and whatever, an email card or something. I don't know what the modern equivalent is. I don't think even those email cards are in vogue anymore. It's probably just a message on Facebook. But some way, somehow, you have to show that we had this interaction, and you have to be able to substantiate the fact that, because if you come into court and say, I had a great relationship with mom and dad, but you can't show that you ever interacted with them in any way, and there's no photos of you guys together, that's another thing. Let's talk a little bit about photos. What about the photos of these, family interactions? What do you think of those?
Well, the photos are worth 1,000 words. If you show, we had a trial once a while back where one of the witnesses decided to come and have their eyes half closed and act like they were, asleep all the time, and they were moody and they were confused. But then you have a series of photos showing them, enjoying life, laughing, having a good time, showing a completely different picture. And you don't even need to spend a lot of time on those. You simply need to ask somebody to authenticate those. By the way, one of the easiest things to authenticate from an evidentiary standpoint is a photo, right? You don't even have to be the one who took it. You just have to be able to look at it and say, that's a photo of Keith Davidson and he's happy. Look, he's happy. Well, of course, we know between the two of us that none of those photos have ever existed for you. But
Right. Yeah.
if there were photos that showed you being happy when you are constantly saying you're sad, those are helpful. Personal injury lawyers have been using photos off of Facebook for years. And when I say personal injury lawyers, the defense lawyers that fight against the personal injury claims, you'll have somebody that'll say they got rear-ended and they can't turn their neck anymore, and they're asking for millions of dollars. And then you go to their Facebook page and they're out, kite surfing and paragliding and skydiving. They're doing all kinds of climbing, mountains. Well, that kind of kills the case, doesn't it?
Yeah. Oh, yeah. And I think you're right. I mean, there's nothing better in the trial that you're talking about. There's nothing better than you introduce the photo, you give a copy to the opposing attorney, you get a copy to the judge, and then you just kind of move on. And it just sits there like this huge bomb just went off in the room, like kaboom, like drop the mic, walk away moment. And it's fantastic. But you got to be careful with photos too, because we've also seen cases where the photo looks contrived. And so you don't want to set up a photo that's kind of trying to show something that it's not showing. And
Right.
so, I think about, I think we had a case years ago where somebody's trying to take a picture with mom and mom's just totally unconscious in bed, and they're trying to move her around and look like she's interacting when she clearly is, not with it. I mean, you can't have stuff like that. But if you have true, honest, sincere photos, they can do a lot of good.
Something else we're seeing of an extension of photos would be videos. And so because we do trust and will contests and we fight over estate planning documents that somebody usually signs right before they die, which transfers a large amount of wealth to somebody, we have some lawyers, estate planning lawyers, when they do a will or a trust, they want to videotape the decedent prior to their passing, obviously, so that they can get show their capacity, show they're not having anybody unduly influence them, and that they're about their wits, and they know who their family is, they know what their property is, they understand what they're doing, creating a will or a trust or something along those lines. But those videos, they're kind of a two-edged sword. I feel like just in about each one of those videos, if I'm going against that video, I can say, well, why do you feel the need to do a video? Because if I was doing Keith Davidson's trust tomorrow, I wouldn't feel like I need to videotape him. And the reason I don't feel like I need to do a video recording of him is because he's got capacity and everybody knows it. But if you're 90 years old, Keith, and I go, boy, I better video record you, am I not just in that act alone saying there may be an issue with capacity and undue influence here?
Yeah, there's a bit of a concession, because why would you video something or somebody that doesn't have any problems? But anytime I hear that, oh, we have video, I cringe. 9 times out of 10, I'm going to hate the video. I like photos much better. And the reason why you hate the videos is, think about, and you've had this experience, Stuart, it wasn't that long ago. Somebody videotapes an elder, and then they start asking the elder questions, and they're like kind of like coaching them. Like they think that they're asking questions that will help, but the way that they're asking the questions, it hurts, because it's like, well, don't, if I were recording, Stuart's mom, and I'm trying to get her to say that she doesn't like Stuart, well, what do you think about Stuart? Oh, I don't know. I don't think about him much. Well, what did you think about when he took your money? Well, what about when he didn't come to your birthday? Do you remember that? Do you remember when Stuart didn't come to your birthday? Oh, yeah, I do kind of remember that. So you don't really like him, do you? No, I guess I don't. Well, that's not helpful. That's just me coaching and getting an elder to say something that I want them to say, which is classic undue influence. And so, and a lot of times it's not necessarily that blatant, but I guarantee you, when you do a video and you ask questions, you probably are not coming across as well as you think you are.
Well, and the problem there is that many of these people that are asking the questions are not lawyers, they're family members, and they're the family members that ultimately are going to receive something. And they're not trained for this type of questioning. And so, unfortunately, it ends up being a leading question, like you're saying, where, hey, mom, you don't like Keith anymore, right? And mom goes, oh, no, I don't like Keith anymore. And hey, mom, you want to give everything to me, right? Yes, I want to give everything to you, rather than, mom, why are you, tell us about Keith. Is there anything going on with Keith? Well, yeah, I'm upset at Keith for X, Y, and Z. See how much
Right.
stronger that is when mom says that? And then, mom, what do you want to do with your assets when you're gone? You know, and mom, has anybody tried to get you to do anything with your assets? These are open-ended questions, and they're not leading at all. They don't suggest the answer. And so if you're going to do a video, you probably should have a lawyer do the video. And then if the
Yeah.
lawyer's doing the video, the lawyer should be careful, because the case you're referring to, the lawyer in that case led that person over and over again. And it got worse and worse because the old guy couldn't hear, and he couldn't hear, and he couldn't understand, and he couldn't process. And so it just got worse and worse. And once you make that video, you got to keep it. You can't destroy it.
Yeah.
That's even worse. So sometimes it's better, just don't make the video. And let me go full circle here. Sometimes it's better when you're mad at your mom or your dad or whoever it is that's going to give you their assets, likely upon their demise. Don't write a text to them when you're angry, because
Right.
texts are forever. Don't write an email to them when you're angry. Emails are forever. If you have to call them, have an argument over the phone, that at least down the road can, it's a he said, she said thing. And not that you're ever going to lie about that, but man, if you send a mean text to your mom or dad, it is so hard to undo that in the litigation process.
Well, and the other thing that comes to mind when you're talking about, even if if a person who's not a lawyer is trying to videotape their parent and ask open-ended questions, the thing that I thought was, why are they even doing this at all? I mean, they must be guilty of something, because why would you do that? People
Right.
don't sit around videotaping their parents by and large. And so you must be guilty of something, or feeling guilty, or feeling defensive, or something.
Right.
And so it goes back to your original premise of, if you're doing a video, isn't it in part a concession that maybe there's a problem here? And so you got
Correct.
to be really careful about these videos. And I think the problem is people do videos thinking this is going to win the day. And boy, it doesn't. I mean,
Right.
it really hurts.
Yeah. The takeaway lessons from our little talk today is, be careful what you text in all aspects of life. Be careful what you email. Be careful what you write, because those could come to haunt you down the road. And so the one thing that I just thought about is, on our email, we recently had an upgrade to the email system that we send, and it gives us the ability to put a 30-second delay after you send the email. And so the email just sits in your outbox for 30 seconds. And there's been a handful of times where I've sent an email to an opposing counsel, or whatever the case may be. And about 15 seconds in, I thought, that probably wasn't a good thing to do. And I jumped into the inbox, stopped the email, fixed it, and sent it again. So, taking a couple deep breaths, get up, walk away from your phone or your computer or whatever it is you're sending these communications on, because they do show up later. And look, I'm sympathetic, because when mom and dad are close to the end, and they're going to be passing away, there's a lot of stressors. And usually there's some sibling issues from the past that come to surface. And so some things can be said at that time. You don't want those things in writing. So be careful with that.
Yeah, and I think one of the best points of advice that you've given clients when they're in that situation, they're afraid something's going on, parents not deceased yet, is you say, be a good son, be a good daughter, be supportive. So if you are going to text an email and you're going to put something in writing, make it something that's loving, supportive, caring, where you're trying to at least be a positive force in this person's life. Because if you're going to put something in writing that's going to come back and be shown to you come time of trial, because it will be, then at least make it positive.
Yeah, no, I couldn't agree more with my own advice there. And that is, and the problem too with parents, and I have two older parents, and you didn't have that experience. Both of your parents died at rather young ages, relatively speaking, and so you didn't have to go through the beginnings of dementia and Alzheimer's, and just getting old and forgetful. It's a tough time for that parent, and that's why there's these laws put in place to protect elders in our communities. And they can be easily undue influenced, and we want to watch out for that. And so that's hard, because we get people that call us and say, hey, I know my brother or sister is unduly influencing my mom. What do I do? And our advice is, look, just love mom, have good communications with mom, because these people feel righteous anger. What am I trying to say? Right? What are they? What am I
Righteous
trying to say?
indignation.
Thank you. And then what they
Yeah.
want to do is they want to go and stop this bad behavior. But the way they go about doing it, they actually make themselves look way worse than the person that's actually doing the surreptitious activity. And so it's better just to love mom and dad and focus on them and their health and keeping them happy. And then when they're gone, there are some things we can do under the law to undo some of the things that have happened. But when you jump in there and try to fix it, and you're screaming and yelling at your brother and sister, and you're sending horrible text messages and emails, you're basically bankrupting your ability to stop that activity after your parents are gone.
Yeah, it's kind of sad, because you shouldn't have to think strategically during that stressful time, but that ends up being what you have to do if you want to be successful later.
Yeah. All right. So, well, this was fun. I'm glad that we had it reestablished to ourselves again. It's always nice to go to trial. Well, I don't know if it's nice to go to trial. It's very stressful to go to trial. But when we do go to trial, it reinforces some of the things that maybe we've gotten a little forgetful about. And so now in discovery, when we're doing discovery in our cases where we're seeking evidence, facts, witnesses, and documents, we have a new heightened awareness that we really need to get those writings that are out there. So we're going to fight hard to get text messages, all text messages over the last few years, all emails over the last few years. And when that person sits down in front of you that you're asking for these documents from, when they sit down in front of you in deposition, don't just ask them, do I have all your emails? Do I have all your text messages? Of course, you do want to ask that question, but don't just accept that. Tell me how you went about trying to get your text messages. Make them give you a detailed analysis of, here's what I did to go and look for and bring the text messages that you've asked for. And 9 times out of 10, maybe even 10 times out of 10, I get strange answers like, well, actually some of my emails, my text messages were deleted. Okay, but you just told me you brought all the text messages, and now we find out some text messages are deleted. Which ones were deleted? And emails, yeah, I did a search for my brother's name in one of my accounts, and I think I got most of the emails. You're going to hear things like that, because people don't want to come out and say, I did what I was required to do, which is a good faith search and inquiry to find every single text message, every single email. And so you can make some inroads there. Fight for those documents, because just one, all you need is one, and it can change the case for you.
That's right. Texts and emails, they matter.
Albertson and Davidson is here to help you fight for your inheritance. Check out aldavlaw.com for our complete library of helpful legal videos and articles from your favorite California trust and will litigation law firm, Albertson and Davidson, LLP.